Before we get into the law, listen carefully to this story. A woman named Alina was driving home after work. It was late. The roads were quiet. Suddenly, flashing red and blue lights filled her rearview mirror. She pulled over calmly, engine off, hands visible. She lowered her window halfway. An officer approached and said firmly, "Roll your window all the way down." At that moment, Alina faced a question most drivers never think about. If she complies fully, is she giving up a legal protection? If she refuses, does she risk escalation? That single decision, window up or window down, can determine whether a traffic stop ends in 5 minutes or turns into something far more serious. Today, I'm going to explain when police can legally demand you roll your window down, when you may refuse, when they can order you out of the vehicle, whether they can open your door, and when things escalate to breaking your window. Most importantly, I'll show you how to protect yourself without making the situation worse. If practical legal knowledge like this helps you, make sure you support the channel so you don't miss future breakdowns. Let's begin. Part 1. Can police force you to roll your window down? The answer depends on context. During a lawful traffic stop, officers are given significant authority to control the scene for safety reasons. Courts have repeatedly emphasized that traffic stops are inherently dangerous for officers. Because of that, judges often defer to what officers claim is necessary for safety. The key Supreme Court case here is Pennsylvania versus Mims. In that decision, the court ruled that officers may order a driver out of the vehicle during a traffic stop, even without specific suspicion of danger, because the intrusion is considered minimal compared to officer safety concerns. This matters because if police can legally order you out of the car entirely, courts are unlikely to say they cannot require your window down for visibility. So, practically speaking, if an officer says, "Roll your window down," and claims it is for safety or communication, courts usually support that authority. But here's the important nuance. There is a difference between rolling your window down enough to communicate and manipulating your window for investigative purposes. That distinction becomes critical in tint stops. Part 2. Tint stops. The hidden legal battle window. Tint stops often begin before you're ever aware. An officer claims your tint looks too dark. You get pulled over. Many drivers immediately lower their windows fully. Now here's the issue. If your window is fully down, the tint is no longer visible. So what happens next? The officer says, "Roll your window back up so I can test it." Now we enter constitutional territory. When an officer physically touches your vehicle or applies a measuring device to gather evidence, courts often treat that as a search. The Supreme Court reinforced this principle in United States versus Jones. That case clarified that physical intrusion onto private property for the purpose of gathering information qualifies as a Fourth Amendment search. Your car counts as protected property. A tint meter touches your glass. It measures compliance. It gathers evidence. So legally, the officer must justify that action. They need one of 3 things. 1, your consent. 2, a warrant. 3, a recognized exception to the warrant requirement. There is no warrant during a routine tint stop. So officers rely on the automobile exception, which requires probable cause, not just a hunch. Saying, "I wanted to check," is weaker than saying, "I could not see any occupants at all." This difference becomes extremely important later in court. If the report says the stop was to verify compliance, that language can weaken the legal foundation. Refusing consent preserves your rights, but it may escalate tension roadside. That's the trade-off drivers must understand. Part 3. Equipment checks. When stops quietly expand after the tint discussion, officers often pivot. They may say, "Turn on your headlights," "Step on the brake," "Use your turn signals." These feel harmless, but legally, each instruction expands the scope of the stop. Traffic stops must remain tied to the reason for the stop. If you were stopped for tint, the mission is tint, not a full vehicle inspection. Unless your state has a formal safety inspection framework, these demonstrations may fall outside the original purpose. Courts analyze traffic stops based on scope and duration. An officer cannot prolong a stop just to fish for violations. But here's the reality. Many drivers comply automatically. And when they do, Officers sometimes discover minor defects that justify additional citations or even arrest authority. Understanding when a stop is expanding allows you to make informed choices. Calmly asking, "Is that related to the reason for the stop?" can sometimes narrow the interaction without confrontation. Part 4. Out-of-state vehicles. Common misunderstanding many drivers believe. My car is legal in my home state. That does not protect you elsewhere. When you drive in another state, that state's traffic laws apply. Courts consistently support this principle. If your tint is legal in your home state, but illegal where you are driving, local law controls. Arguing it's legal back home almost never helps. In fact, it often prolongs the stop. Researching destination laws before long trips reduces unnecessary exposure. Part 5. Can police open your door? Now we move into more serious territory. Can an officer open your car door without permission? Opening your door is a physical intrusion. Courts treat that differently from simply ordering you out. The Ninth Circuit addressed this in United States versus Ngamizi. In that case, the court held that opening a car door during a traffic stop was a search under the Fourth Amendment. The officer needed a specific safety justification. General curiosity or better visibility was not enough. Here's the distinction. Ordering you out? Usually allowed. Opening your door without warning or justification. Much more legally sensitive. But roadside reality differs from courtroom theory. If an officer opens your door unexpectedly, sudden reactions can escalate fast. Staying calm protects you more than arguing in that moment. Documentation later is safer than confrontation now. Part 6. When escalation leads to broken windows, the most extreme scenario involves officers breaking a window. When does that happen? Usually after repeated refusal to exit, claimed odor of marijuana, allegations of impaired driving, claims of safety risk. Courts often side with officers if reports show escalating noncompliance combined with stated danger. Judges frequently frame window breaking as removing a barrier, not using force against a person. That framing legally protects officers. From a practical standpoint, once an officer issues a lawful exit order and it is ignored, escalation becomes likely. The roadside is not the place to litigate constitutional theory. That fight happens later. The goal roadside is safety. Part 7. The partial window strategy. Many drivers ask, what if I lower the window halfway? This approach allows communication, document exchange, some visibility. It may reduce tension compared to full refusal. However, at night or with dark tint, officers may still insist on more visibility. Body language matters. Sudden movements increase suspicion. Clear speech and slow motions reduce perceived threat. Partial lowering is not immunity, it is a tactical choice. Part 8. Exit orders change everything. Once you are ordered out, control shifts dramatically. The Supreme Court extended officer authority to passengers in Maryland versus Wilson. Officers may order everyone out. After you exit, you may legally lock your vehicle. Locking the door raises the legal threshold for entry. Officers then need consent, a probable cause, exigent circumstances. Silence helps here. Voluntary statements expand authority. Calm compliance with physical commands while declining unnecessary conversation balances safety and rights. Part 9. The smartest way to handle a window demand. Here is the practical hierarchy. If the officer demands window down for communication, comply enough to communicate. If the officer demands full down for investigative reasons, understand you may preserve rights by declining consent. If the officer orders you out, comply. If you wish to challenge legality, do it in court, not roadside. Winning the encounter is not about ego. It's about leaving safely with minimal damage. Final thoughts. Traffic stops turn on seconds. Window position.
Tone.
Movement. Timing. Small decisions shape whether authority expands or stabilizes. The law often favors officer discretion in the moment, but knowledge changes how you respond. The objective is never to beat an officer on the roadside. The objective is to stay calm, avoid escalation, preserve rights, fight improper conduct later, if necessary. Because once emotions rise, constitutional theory rarely controls the scene. Understanding these boundaries gives you leverage without confrontation. If this breakdown helped you understand how these encounters actually work, support the channel so you don't miss future legal strategies that can protect you in real-world situations. The next video will break down common police questioning tactics and the smartest ways to respond without incriminating yourself. Stay informed.
Stay calm.
Stay protected.